Good afternoon. My name is Tom Donnelly, and I'm the humble moderator for this afternoon's discussion of ethics and legal writing. And I'm going to ask our panelists to introduce themselves, starting with Professor Hopkins.
Hi, my name is Kevin Hopkins. I'm a professor here at John Marshall Law School. I teach torts and advanced torts.
Judge Frost.
Hi, I'm Kim Frost from Houston, Texas. I'm so pleased to be here in Chicago with you. I'm currently the Chief Justice of the 14th Court of Appeals in Texas, which has a 10-county jurisdiction, hears both civil and criminal cases. Before I took the bench, I enjoyed a 15-year civil trial and appellate practice with 2 Texas-based firms. I'm a graduate of the University of Texas, have a BBA in international business and a BA in government, a JD from Texas Tech University School of Law, and an LLM from Duke Law.
And I'm Dennis Rendelman of Springfield and Chicago. I'm currently ethics counsel in the Center for Professional Responsibility at the American Bar Association. Prior to that, I taught at the University of Illinois Springfield in the Legal Studies program, including teaching research and writing. And prior to that, I spent 23 years with the Illinois State Bar Association as general counsel and various other titles, some that can be repeated and some that can't. And I also serve with Judges Donnelly and Hyman and Professor Hopkins on the Illinois Judges Ethics Committee, which issues advisory opinions on the Illinois Judicial Code, and that's good enough.
All right. As Justice Hyman noted, I'm genetically incapable of standing or sitting behind a podium, so I'm going to get up and get around and maybe get some participation. But first, I wanted to find out one vital piece of information from the panel. How many of you are legal writers among this group? Or how many are legal readers? All right, and I think that's where we want to center things, is that we are all readers. And for us, when we were preparing this presentation, what really came to mind is that all writing must be reader-centric, that we want to do the reader's work for them in our legal writing. And that is one of the fundamental principles of any legal writing, is that you want to make your writing accessible so that the reader understands what you're trying to say, understands why you're saying it, and understand what the support you have for those ideas. If you fail to follow those fundamental principles, the most devastating consequence of failing to follow those principles is that you won't be effective. And particularly in writing for judges, I used to teach legal writing at Loyola Law School, and one of the principles I would always try to inculcate with my appellate ed class was, if the judge doesn't get your idea in the first paragraph, they probably never will. You have to front load the things that make you win immediately, because after the first paragraph, we begin to lose heart. And we're sort of going through searching for the thing that's going to help us rule your way. But if we don't find it in the beginning, we believe it's probably not there. And why is that? The rules of primacy and recency. The first things you say, the last things you say, are always the most effective. Now, in addition to the implication that you may not win, there are other implications of bad writing. And we'll talk about some of those today. Some of those may be sanctions or reprimands that are issued by courts. But really, I think those are the last thing you want to be worried about, because if you really are concentrating on being effective, you won't have to worry about other implications like sanctions or reprimands, because effective writing is honest and forthright, is a quality product that helps the court do the right thing. And so we're going to talk about a few of those principles, first from the perspective of attorneys writing, and then we're going to talk about judges and the ethical rules governing judicial writing. So Dennis Rendelman is going to lead us through a few of the principles regarding attorney writing, and we'll continue from there.
So let's start with one of the most basic things that we are all confronted with, whether we like it or not, which is, of course, citation. And there is a widely respected federal judge who has perhaps mirrored my feeling about citation. We all are confronted in law school and in the rest of our lives with something called the Blue Book. And this particular gentleman has been quoted as saying that the Blue Book is 560 pages of rubbish and should be burned. I have to agree with Judge Posner in his analysis of the Blue Book. In his 1986 review of the 16th edition of the Blue Book, he said, "The Blue Book is elaborate but not purposeful. Form is prescribed for the sake of form, not of function. A large structure is built up all unconsciously by accretion. The superficial dominates the substantive. The vacuity and tendentiousness of so much legal reasoning are concealed by the awesome scrupulousness with which a set of intricate rules governing the form of citation is observed." We might say that about that sentence, too. When I was teaching, undergraduates and graduate non-law students, and rather than try and inflict the Blue Book on them, we used the ALWD, which was a much simpler system, but it was still a system that was even more complex than Justice Posner's approximately 5 pages of citation rules that he uses both in his cases and in his other legal writing. And I think the point to be made here is that the purpose of citation is not the furtherance of the Blue Book. It's the ability to convey your resources and your authorities to the reader so that the reader can find them.
And as judges, when we were doing conference calls about this, of course, this is vital for us. And I think Judge Frost and I both share this opinion that case citations without pinpoint cites just make work for the court. They are not reader-friendly. So if you have to search through the whole case to find whatever proposition in a 50-page case supports the author's assertion, it really is not a friendly opinion. The other thing is that good parentheticals, giving the facts of the case, are very helpful. Now, Judge Frost has the advantage in that her court has the ability to use hot links to get to different cases, so it's a little different perspective.
Right.
Than.
And pinpoint cites also sort of work as a check for the lawyer, because if you have to go and put the pinpoint cite in there, you know you are being faithful to the proposition that you were citing the case for. So it really is a good measure, just as in terms of practice, to go to the pinpoint cite, verify that what you're saying about the case is right. And now, in a very technological world, judges and staff attorneys and everyone who's reading briefs has the ability. In my court, for example, we can, press the. If you're reading the brief electronically, you can press the case, and it will instantly take you to the case. If you press on the record site, it will take you there. So now, more than ever, judges and staff attorneys are going directly to the source document.
And I think if you look now, as more and more states are going to what is in essence an open source form of citation, we're going to see increasingly the move toward the system that was just described. With everything electronic, the hot link method of citation is going to be superior to anything that we've seen before, and probably will be replacing, if we do this conference in 5 more years, we won't be talking about paper-style citations, but electronic hot-link-style citations. But one area that even Judge Posner says is useful are the signals. And in using signals, the issue is how clear and how uniform can the signals be. We have a variety of signals that are fairly well understood and can guide the reader to appropriate authority. But will those still be necessary when we have hot link citation? We put up on the screen some of the most common signals. But if you look in your blue book, you'll find that there are a wide variety of additional signals. Do we need them all? I'll ask the judges, how many signals do you need? Do we need semaphore signals? Do we need C but C? Do we need C? Do we need C also? Or is it just confusing?
Well, I'm an appellate judge, so I like them.
How many? How many do you like, and can you distinguish between some of the narrower focus signals?
Well,
or does a case...
We tend to, the way, on our court, use them as they're put in the blue book. And I think it probably depends on an audience. If you're writing to a general audience, and certainly if a layman wanted to be able to understand a judicial opinion, and they should be able to do that, they're not going to find those very useful.
Is it more useful to have a parenthetical that explains rather than just using a signal, or is a signal with a parenthetical superior?
I prefer a parenthetical. Both are fine, but I like the parentheticals because I think it forces the practitioner to get behind the accuracy of what they're saying. And I think people who use parentheticals tend to be more faithful to the text.
And my feeling is the text of what the author is saying usually should be the holding. The parenthetical are the facts that undergird that holding, so that I know how far that holding extends. And that's very helpful. I think the signals are of really only amplify what's in the parenthetical, that if the case is really not on all fours, that's where the CF is appropriate. That is reflective of what's in the parenthetical already, that it is a dissimilar case. If the case law says there's a distinction between arm's length transactions between sophisticated parties, and this is a ma and pa case, it's really important that the person admit it's a ma and pa case, it's not an arm's length transaction. So while it's a holding with respect to fraud, I want the attorney up front, even when they're applying it, to say maybe CF, telling me it's not directly applicable, and tell me it's a ma and pa case in the parenthetical if the case we're applying this to in the trial court is a arm's length transaction kind of case. And to me, that's about credibility of the lawyers. If they try to pawn off a case that's really not applicable as directly on point, my credibility rating for that lawyer plunges dramatically. So I want to see that they're giving me the information about what the facts of the underlying case are, at least enough to see the extent of the holding.
And that raises the point that I wanted to make specifically about the audience. Many of these signals, while useful in a law review type of context, come across as, I don't want to say disingenuous, but perhaps misleading if you're doing it in a brief to a court, because you're bringing in material that really is distracting to your main point, or to your argument. Whereas in a law review context, you're simply bringing in additional information that a scholar reading it may find interesting and may send the scholar off onto another track of thinking. But that's not what you want when you're doing a brief to the court. You want the focus on the main point and not sending off on some alternative or trying to bolster your point with something that's really not directive. Which, again, takes you back to the pinpoint. You want to focus, and as we have more, I think I may have already said this, open source, your pinpoints become better because you're citing to the actual paragraph, not just to a page.
How many in their jurisdictions have open source where their opinions are divided by paragraph now? So it's still a minority of jurisdictions.
Or public domain is another word they use for it. Okay, I think we want to, where are we on the slides here? Yeah, let's kick ahead to the next pinpoint, yeah. One of the issues with pinpoint sites, and something we really didn't talk about before that I wanted to raise, was pinpoint sites versus actual quotation. How much, judges, do you value quotation from the source as opposed to the pinpoint site? When is quotation beneficial versus citation?
I always value the pinpoint site. I also think paraphrasing is a better option in legal writing than citation. Than quotation when it's possible.
Yeah, block quotes for me are anathema. I just, if I wanted to read the case, I'd read the case. I want you to articulate for me, and the paraphrase plus maybe a quotation of a key phrase, where you say there are 3 or 4 words I should pay attention to in this case, and this is the 3 words. So a paraphrase plus a very laser-focused emphasis on one particular phrase or aspect of the case that helped me.
Versus scholarly writing, the law review?
Well, versus block quotes where they'll quote 3 paragraphs of the case, indent, and expect me to try to find what crucial gem is there in that block quote that helps them win their case today, which is not helpful at all.
Thus saith the judge. It's interesting to try and parse the format that you use, and we've got a slide up here on the style that comes out of the Blue Book. But if you read, for example, the Illinois style manual, the focus is, again, not on the West publication, but the Illinois style manual, the Illinois court style manual, directs you to use the Illinois official court, which is the Illinois open source that takes you, that's basically the date, the court, and the paragraph number. And that cuts everything down to about half the length of what this citation is. So I think we're getting, and probably sooner rather than later, well, I'll ask you, how would this look in a Texas citation with your hot links?
Well, it would just be underlined like that, and you would press it.
There'd be
it looked exactly the same. Only
with none of the numbers, with none of the.
No, it would have the numbers. Looks just like that.
And do you have an open source citation to it, or has it jumped over that directly to the hot link?
In the application, for example, in my court software, it will take you to the case in whatever service you use. So
Okay.
Westlaw.
So it does get you into the proprietary
Yes.
and not just to the public domain or to a public domain.
Right.
How many, we ask about the public domain, how many have any type of hot link connections like Judge Frost is talking about?
Texas is the only
Texas
one.
is the only one.
And the Fifth Circuit.
Texas is leading the way. Let's go ahead and talk about case history issues. Now, one of the things we talked about in preparing is just how much history is too much history. When you're looking at the nature of a case, you know, obviously the court wants to know when that you've done your job in making sure the case has been what we used to call sheph'd. That doesn't refer to the Three Stooges, but nonetheless, it is often akin to trying to follow the Three Stooges. And as we've cited to the Texas appellate court standards, it's the duty to inform the court. And it goes again to credibility, etc. But one of the things that we always want to know is how does it apply to the point that you want to make? And sometimes, once again, you have to delve into the textual material to make sure that the case or the point that you're aiming for is why it was reversed. There may be times, and I've certainly come across that, where there's material in a case, even though it's been reversed, that is still valid for your case, or your law review, or your piece. One of the issues that we talked about in preparing for this is what I call sort of the deceptive or the devolutionary common law, where you will have a case previously that stood for a proposition, and then as various courts go on, they always, and we'll get into this momentarily, they always want you to cite the most recent case. But as the courts travel along their merry way, they start changing what that original case said. And you have to sometimes go back and look at that original case to make sure that the most recent case that you're looking at really hasn't been undercut, hasn't been diminished, or as we talked about earlier, there haven't been two separate lines on a case where the history has diverged and one branch has turned into one form of ape and the other branch has turned into a different form of ape.
Yeah, I think this is, it's something that I run into is that they will cite the last case that cites the signal case, and it's citing only this in passing. It really isn't a central part of the case. So to understand the doctrine, you really have to go back to the original case, and it would be much better if they cited the 1983 case than the 2016 case, and maybe just said, CEG or some other signal after it, or accord the other cases. The 2016 doesn't really help you because it doesn't articulate the holding as well and the doctrine as well.
Right. And I think the point for ethical consideration in writing is that when you mention a legal principle, you must discuss it fairly. You must portray the law fairly, and that means completely and accurately. So if a case or a line of cases has evolved, you need to discuss it in a way that makes the principles clear. Another example might be if there's a general rule and you discuss the general rule and you fall squarely within that, but the advocate doesn't mention the exception, which might make it more questionable whether you fall within it. So if you're discussing a general legal principle and there are exceptions to that rule, you need to address that yes, there are exceptions and no, we don't fall into them, or yes, there are exceptions, and then unpack why they may or may not be relevant. But that's part of the lawyer's obligation in legal writing to be candid with the court and paint a complete and accurate picture.
I had a case, amicus brief I was working on at ISBA where we were doing the research and went back to the original Supreme Court, Illinois Supreme Court opinion, and basically discovered that the courts thereafter had continually interpreted the Supreme Court case wrong, and had an entire section in our brief arguing what the original court opinion said, and then talked about the 5 or 6 cases subsequent that had been misinterpreting what the original Supreme Court opinion was. Didn't help any, but I felt better about it. And it really was sort of, and that is not the only time that I've discovered situations where a statute is interpreted one way, and suddenly you find, well, now that's really not what it said.
And we've had a recent experience with that here in Illinois. We had, over the years in unemployment security cases, we had developed a case law that said if somebody did something that was against common sense, they weren't entitled to unemployment insurance. The statute really didn't say that at all. It listed 3 categories for termination, which would you'd lose your eligibility for unemployment insurance. So over the years, the case law had developed. Illinois Supreme Court went back just a couple weeks ago, looked at the original statute and said, there's nothing in there where there's this common sense exception. Mm-hmm. And I bet it was the advocates drawing their attention to the original text of the statute, that this was something created over time by the appellate courts that originally meant criminal acts, but then extended to everything. And the particular facts of this case were that the United Airlines personnel, a tower controller, had decided to upgrade a passenger into first class and give them a bottle of champagne. And this was the grounds for termination because it was unauthorized. And the court said, well, that is not sufficient to terminate unemployment benefits because the statute doesn't allow it. There are very narrow grounds. And so it's that opinion that going to the original source can sometimes be very helpful as an advocate.
Right. And addressing the principles of law that are applicable to the case is it's always good strategy, not just good strategy to address the ones that are in your favor, but addressing the unfavorable principles of law is good ethics and good strategy, because the court's able and alert staff, as well as the judges, are going to take a deep dive into the law. They are going to uncover whatever unfavorable principles there are in that case, or your opponent will, and you'll hear about it in a reply brief or an oral argument. So, representing the law accurately and completely is the best strategy, and it also will work to build your credibility with the court. So being upfront about unfavorable principles of law will actually, behoove you in the long run.
And with respect to the dilemma of choosing the most recent cases versus the older cases, I used to teach writing, and I have taught writing, and I will always teach my students to clearly look for the newer cases. But if there is an older case that all of the newer cases are citing to, then pull it, or cite to it. And the Blue Book gives us a kind of a compromise position, a way to sort of use the new case law, but also to cite back to the old case law.
Yeah, I know I had one situation in when I was clerking, drafting something, and one of the judges says, well, why are you citing this older case? That's not the most recent thing we've said on it. And my response was, yeah, but the most recent thing we said on it had no similarity to this case. This older case was directly on point. And it was, oh, okay.
You know, I think we should, Judge Frost has already started to cover disclosing adverse authority, and maybe we should go to that segment of our presentation because we're a little behind on time. But we'll get back to Dennis in a bit.
No, go.
Okay. You know, there are ethical considerations at play in dealing with conflicts in case law. They tend to arise in three scenarios, perhaps more. The first is the court has weighed in on the conflict in the advocate's favor. In other words, there's a split of authority among courts, and you're in the court, and they have the rule you want. In that case, there may not be any need to alert the court that there is a conflict on ethical basis, but it still might be prudent to do so. For example, the court's decision might be a very long-standing one, and the conflict from another jurisdiction or another court arose more recently. So the advocate could disclose the split of authority and state for the court why the long-standing rule is the right rule. Because again, even if you don't point it out, opposing counsel might, or the court might discover it on its own, and to have your input on how to deal with that conflict, it would be helpful. The second scenario is one in which the court has weighed in on the conflict, and it's on the other side. You are on the wrong end of the conflict. And so what do you do in that situation? Well, the rules provide that the advocate must identify the conflict and then state which courts have weighed in on which side. Of course, having done that, the advocate may then urge the court to adopt a different rule, bearing in mind that a change like that would probably require an en banc decision. The third scenario that splits in authority come up is the court has not weighed in on the conflict at all. And so in that scenario, the advocate should identify the conflict, state which courts have ended up on which side of the conflict, and then take it one step further and explain the logic on each side of the conflict, and then advocate for the side that favors your side of the case. So when you're dealing with a split in authority, just be mindful that there are ethical considerations that accompany that in legal writing.
All right, we're going to go on to the use and value of unpublished decisions. Is that right? How many in your jurisdiction do you have unpublished appellate decisions? Okay. And how of those is it a violation of the rules to cite those in briefs or before courts? All right. So a minority.
They're on the internet apparently, but you can't cite them, even if there are 5 cases going your way.
In Texas, the rule is different from Illinois. Illinois, it's a violation of the rules to cite them.
Right. We have sort of a hybrid. In Texas, you may cite, the lawyers may cite to unpublished cases, but you must indicate that they are not published when you do so, and published cases have no precedential value. So it's sort of this middle road. Unpublished cases have no precedential value, yet lawyers are permitted to cite them as long as they disclose the limitation. So it's a strange world where unpublished cases are being cited in briefs, yet because they lack precedential value, courts should courts consider them, I guess is the question. Many judges feel that cases that lack precedential value should not be considered.
It's sort of like our kids playing, you can't see me, you can't see me.
Right. But we do have problems arise when courts treat unpublished opinions as if they did have precedential value. And one example that I have seen a few times is including unpublished cases in surveys of the law. For example, if an advocate is writing a brief, or I guess more appropriately, if a court is including a survey of cases in the legal analysis, and they start saying, this court has held this, and cite an unpublished case, this court has held this, and maybe that was a published case. But if you include the unpublished cases in the survey, really there are a couple of things that need to be noted. First, the courts that issued those unpublished cases did so with the expectation that they would not be precedential, and they're being treated as precedent in that. Second, if you're counting them in the tally, you can really skew the analysis, and you could make what is a majority view look like an aberration, or vice versa, if you include those published cases. And sort of a third consideration is more a matter of process, because if a court looks to unpublished cases in some circumstances but not in others, you sort of have a process question there. Some of you may remember Justice Scalia raised this issue in the statutory interpretation or use of legislative history context, so that if you conduct a survey and you use the unpublished cases one time and evaluate what happens there, do you need to do that every time? The next time, what if you don't use the unpublished cases? It's not, it would not be consistent. You also sort of have an efficiency problem, because if all the judges are looking at cases that have no precedential value and using those as part of the analysis, and you do that every time, then that's a lot of judicial resources going to evaluate cases that have no precedential value.
And as a trial judge, I'm very frustrated by this, because often I find that there are unpublished cases that are closest to the facts I have before me, and that there are no other cases with similar facts. So I'm very grateful that the litigants have cited it, but then, of course, the other side says, well, but that's a violation of the rules to cite this very helpful opinion. What are folks' thoughts on that in the light of the fact that all things are now virtually published by the internet? What is the view of practitioners or other judges?
Well, Ohio got around the problem, or made it worse, one or the other. All decisions of all courts of record that are done are public. And they did away with book publishing. It's all just online, non-proprietary. And so any case is published. They also said there's no difference between published and unpublished decisions. So they all have the same authority. Now there's still one caveat, and that is the courts of appeals have the ability, only some of them do it, to write what's called a judgment entry, which is a very summary thing saying we don't see anything wrong with
like
it.
a per curiam?
Yeah, those are not published, and so you can't cite those, but they don't usually have their own facts. But right now there is no distinction between published and unpublished.
And how is that working out?
I think it's working out fairly well. Because before you could cite a published and unpublished decision, it simply didn't have the same weight. And then when they did away with the
So like the Texas.
distinction, they said, well, all decisions are the same and they have the weight that any court wants to give them, which makes no sense, because technically there'd be no binding precedent at all.
Well, the irony.
It still works out that, yes, it is a binding precedent of above you somewhere.
Well, the irony of all of this is that it wasn't just a publish, non-publish, precedent, non-precedent when it was established in Illinois, it was supposed to be the way you describe your per curiam or your what have you. It was supposed to be something that there was no dispute about. It was so simple, and it was just supposed to be what we called a Rule 23 order, which was, which I would categorize as a so damned obvious. Whatever this was, it was so damned obvious that it didn't need legal reasoning, so on and so forth. But it never was. It was used by courts, present company accepted, of course, to either hide a decision that they didn't want to make public, or something that they just sort of wanted. I'm sorry, I don't have time to keep this short. So it was something long and then the court came down with page limits and opinion limits. So each appellate court could only issue so many opinions a year, and they could only be so long. And this was still with the publication issue, because the libraries were getting too big and it cost too much. So then we ended up with the phenomenon of appellate opinions, where Part 1 was an opinion, Part 2 was a Rule 23, Part 3 was an opinion, so they could stay under their page numbers, and it continued to make no sense whatsoever, and no one was ever called on the fact that, well, this Rule 23 really establishes something. It's not just so damned obvious that it should be thrown out. Can I tell my story now? Do we have time?
We do, and then we'll move on to Kevin.
I had was clerking, and we were in one district. We issued 2 opinions that were opposite, something that rarely happens, issued them on the same day. We had another district that had an opinion that went one way, another district that had an opinion that went the other way. So here we end up with 4 opinions, the opposite. The Supreme Court decided it on an appeal from a Rule 23 in yet a 5th district that none of us knew anything about because it was a Rule 23. How can you call that a reasonable method, and particularly how can you call it a Rule 23 when you had these other districts with different opinions? Okay.
We're going to move on to Professor Hopkins with the ethics of writing.
Hi, I'd like to briefly just talk about 4 common things that I think often occur in legal writing that create ethical implications. First, I'd like to talk about the recycling of old documents, for instance, the cutting and pasting of materials. Computers have made it so easy today to just hop on the internet and to cut and to paste. We've got a great, I think, cartoon that sort of indicates at least this whole thing with regards to being able to hop onto the internet and cut and paste information. Second thing I'd like to talk about is using quotations and paraphrasing. That seems to be a big issue, and as Judge Frost indicated, she would prefer paraphrasing, and I would prefer paraphrasing also, but I'll talk at least as to when quotes might be more effective. 3, misrepresentations of law and inattention to court-imposed word limits. Failing to disclose information may very well trigger allegations or the implications of misrepresentation under the ethics code. So I'll talk a little bit about that. And then finally, typographical errors, clerical errors, and the unfortunate effect that they can have on a client. Let me start with cutting and pasting, and I'm going to refer back to at least a scenario that I used several years ago. A lawyer is asked to prepare a document for client A and later discovers that his or her own law firm's electronic brief bank contains a document previously prepared for a similar transaction. And as you read on, at least, the lawyer just simply goes into the brief bank, pulls the document up, cuts and pastes, takes the information, puts it into the new document. That raises all kinds of, I think, ethical issues. First, context. Cutting and pasting, if you're going to cut and paste, you've got to make sure at least that it fits into whatever it is that you're trying to say in the new document, so there may very well be context issues. Second, citation. We can't escape the fact that we've got to cite to authorities, especially if we're using someone else's ideas or work products, so that doesn't give you at least a pass in not giving proper citation. Updating case law. Clearly, if you're going to cut and paste, if it's an older document, you want to make sure that the case law is the most current, and so you can't just kind of cut and paste and stick it into a new document without at least trying to update or shepherdize the case law. And then finally, billing issues. I've talked a little bit, at least in my own writings, about the implication of double billing or double billing under Rule 1.5 with regards to proper billing of the cutting and pasting. For instance, if it only takes you a few minutes to cut and paste, do you bill the client the full amount for that? That seems to raise, I think, some ethical issues. Let me move to quotations. We've got, an interesting slide with regards to quotations. Don't believe everything you read on the internet just because there's a picture with it and a quote next to it, and I've got Abraham Lincoln there. I think it is kind of a profound statement with regards to quotations. But let me just dive into some basic tips that I think might be helpful for you as you are using quotes and especially for the law students in the audience. First, quotation marks and proper citation to authority are always required when using the words or ideas of others. There should be at least some type of citation or some type of attribution, so please don't, and whether that be using quotation marks if you're directly quoting something or citation if you're just referring back to something that someone else has used. Use quotations sparingly. I agree with Judge Frost on the panel. Lots of times, one of the interesting things about legal writing is that it allows us to use the language of other people. We don't always have to reinvent the wheel. That gives us permission to quote and to quote and quote. But if you've got an entire document filled with quotation, then that's going to take away from holding the attention of the reader. So please use quotations sparingly. Plus, there may be times when you might think that a quotation is extremely important, especially if you're, for instance, referring to a statute. You might want to quote, or you should probably quote the specific language of the statute. C, do not quote from headnotes. We didn't talk about this, but it is in our presentation. It's so easy to look at that first page of the case and then to kind of quote to it. Do not quote out of context. Once again, make sure that whatever it is that you're quoting, it fits into the context of your document.
And the judges had a response to this. We don't really care if you plagiarize, but just understand the thing you're plagiarizing from and make sure it applies in the case, which is often the case. Is I'll get motions eliminated that they've copied from some brief bank, and they've never read the cases they're citing. And it's like, well, it's just, especially when one of them or two of them don't stand for the propositions that they're relying on them for, and it's really distressing. So the plagiarism for us, we don't have the ethical issue as much as just the functional issue. Is this really something you know anything about?
And I'll take it a step further, not just from headnotes, but from digests where the case was. I've seen, and I can understand the pressure because I've seen it particularly from some government briefs where, they've got 4 million briefs all due the same day, and they're trying to get these things churned out. But I've seen briefs where there's a citation to a principle that came out of a digest book, and you go look up the case, and it's like, are they checking anything before they put it in the brief?
I have one example that happens all the time in our trial courts. There's a case that stands for the proposition that a lawyer may not use 51% as the burden of proof, that's inaccurate. What that is cited for is that no one can use any other language other than our jury instructions, which is more probably true than not true. Well, that's not the same thing. You may be arguing that should follow from that you can't say 51%, so that means you can't say anything other than more probably true than not true. But certainly that case does not say that. And it's just very distracting.
Hey, look, she's giving us a 10. I think we're doing okay.
Sure. The next topic I want to talk about really quickly is just misrepresentation. And let me just raise a few of the issues that I think occur with regards to potential misrepresentations in your writings. Embellishing, misstating facts, or failing to disclose relevant facts or updated case law. presenting a disputed fact as one that is uncontroverted, undisputed, or uncontroverted, citing to the general rule but not to the exception, making frivolous arguments. Beware at least of the potential for misrepresentation. Finally, I've got two more points to just talk about really quickly, and they are the inattention to court-imposed word limits. As a lawyering skills professor, and having students or having my students at least write documents, I give them a page limit. And students are very crafty, or lawyers can be very crafty with regards to at least the page limit, right? We can change the font, and we can get 200 words into a page or something to that effect. I believe that it raises potential, or at least the inattention to court-imposed word limits, implicates Rule 3.4, fairness to opposing party and counsel. A lawyer shall not knowingly disobey an obligation under the rules of a tribunal. So please beware of that. And then finally, I want to just jump over to typographical errors and clerical errors, which I think implicates Attorney Rule 1.1, competence. I think competence includes the following: knowledge of the applicable law for legal representation of a client's interests, the ability and skill to perform basic legal research, and the ability and skill to draft pleadings and documents correctly. Beware, at least with regards to your representation of a client, errors like typographical errors can create major problems for a client. And unclear writing and ungrammatical sentences could very well also implicate sanctions by the court. I brought in a Kentucky Bar Association ruling 2000 where the Supreme Court at least suspended an attorney from the practice of law for drafting a brief on behalf of his client that was, and this is the quoted language from the court, a little more than 15 unclear and ungrammatical sentences slapped together as 2 pages of unedited text with an unintelligible message. Wow.
That's what
Action-packed statement, at least here. So I'm going to turn it back to Judge Donnelly, at least
And
at this
Judge
point.
Frost is going to talk about using facts not in the record.
Well, part of an advocate's obligation, of course, is to represent the facts fairly. And the facts, for purposes of the appeal, are those facts in the record. So as appellate advocates are writing, it is inappropriate to rely on, cite to, or utilize facts that are not within the record. And usually this comes up, the advocate is really just trying to be helpful or to give what they believe to be a full or complete picture. But for purposes of appeal, it's very important to remember that the full picture is what's inside the record. And if it's not within the record, then don't rely on it, don't cite it. It would not be appropriate to do so. And I just would also reiterate that lawyers have an obligation to disclose unfavorable facts that are in the record that are relevant to the issue. And once you've disclosed them, then of course you may vigorously challenge how they impact your case or distinguish them or explain, minimize them, but it is absolutely incumbent upon the appellate advocate to disclose unfavorable facts and deal with them. Remember, the court is going to have to deal with them, and so having to disclose them is your opportunity to show the court how best to deal with those facts.
And now we're on to judicial ethics, and we're going to put up a few excerpts for you, and I'm going to get your opinions on whether these are clear and incisive writing examples or whether they may be a little bit over the top. So what are the rules governing? One of the things that we have as judges is a rule to show respect for the parties in our courtroom demeanor and in our writing, of course. So how does that get, or how does that interplay with our ability to be effective writers and grab the reader's attention? So we have a couple of examples here. And so this is the first paragraph of an opinion written here in Illinois.
And what's your evaluation of this? Is this a very clear expression of what the court's finding and the person's conduct, or is it over the line? What are the thoughts you have? Okay.
And actually, it's sort of, I was over the line, but in a condescending kind of way towards the unhappy litigant. It sort of portrays a little bit of a psychological wrong person. So.
And what if that's accurate? Is that fair to do, even if it's
Well,
accurate?
Sure. It's illegal. It's not fair. I think, when we think about opinions and things, you kind of, I don't mean to offend anybody, but, you dumb it down. And that's the hardest thing I'm having as a first-year student is, I love those words. I mean, consummation and tragicomic and
But the
all.
comment you made is it's condescending, the way
Yes.
it's treating the litigant. Other thoughts on this? Is this expressive writing or wordy? What's that?
It's just wordy.
It's wordy, so it's not only maybe condescending, but it's prolix.
It also, Judge Donnelly, sounds a little mean-spirited. It sounds like you're slapping the petitioner on the wrist.
So our thought was that the judges also have responsibilities in how they treat litigants in their writing. It's something to be aware of. And Judge Frost, you were going to close with some few thoughts.
Well, in terms of judicial writing, I think no one sets the tone for practice and professionalism more surely than the judge. So if judges lack civility or professionalism in their writing, then the lawyers are going to pick up on those signals and those messages and feel free to relax their standards too. So to foster professionalism in legal writing, judges must model it. And some of the specific things that are in the standards of appellate practice are not to reward departures from the record, not to disparage the professionalism or the integrity of counsel based on the conduct or reputation of counsel's client or perhaps even co-counsel. And it's important to remember that the court's role is not to ridicule the parties or their positions, but simply to apply the law to the facts of the case. So a careful, talented writer can be interesting, engaging, and even humorous and clever without ridiculing the parties' positions. But for most, it's a risky thing, and you have to be careful because you need to always remember there are, people and companies and organizations behind those faceless sets of appellate briefs. And for those people, they care deeply about the issues and the writing, and they want the court's serious attention to the matter, and they might misinterpret what the court thinks is a clever turn of the phrase and think that's not being serious about their issue, and they want to have their day in court. That's not to say you can't be interesting in your presentation, and there are some very well-written judicial opinions that accomplish that goal without belittling the litigants or the positions they've taken in a case. So I guess my final comment would be that we should all abide by the same standards of professionalism. The judges, as well as the counsel in the case, should be fair in their treatment of the facts. Courts have a special responsibility to get the facts right. I mean, we're all trapped in the human condition. We're going to make mistakes. We are imperfect people applying imperfect laws, and sometimes you miss it when you apply the law, but you should not miss it on the facts. You should always get the facts accurately stated in the opinion, and judges also have an obligation to correctly recite the issue that has been presented. Now, sometimes that issue is not presented clearly, and so you have to try to interpret what that is. But judges have a responsibility, of course, to state the issue fairly. And like counsel, to treat parties and other judges and courts honorably and respectfully. When I was a young lawyer, my mentor always told me, attack the ruling, never attack the judge. And that is a good rule to always, you do attack the ruling. That's what you do on appeal. You are attacking the ruling. But don't make it personal. Don't attack the judge or the judge's competence or intellect. Just attack the ruling. I think also judges, when they're writing, can remember that they can vigorously disagree with their judicial colleagues without being unprofessional about it. And I also think it's an important corollary that when there is disagreement among judges on the bench, that it's very important that judges write, especially in that context, with precision and accuracy. Because on the other end of the continuum of being unprofessional is being so diplomatic in the way you discuss a case that the reader can't really tell. They can tell you're not following it, but they can't tell why because you're so diplomatic. And so when you're discussing cases, I think a judge has an obligation to be clear and precise and say, I disagree with this because of X, Y, and Z. That helps our jurisprudence develop. If you just try to be too diplomatic about it or say it too politely and the reader can't tell where there's a split of authority, then that just muddles the jurisprudence, and we're not doing a good job if that's what we do. So if a conflict is not flagged, the conflict will never get resolved. So that's important too.
And we are precisely out of time. So I want you to join me in thanking this wonderful panel.